All right, welcome. So glad that you are joining us here today for our life and legacy planning presentation. In our time this afternoon, I will talk about some of the reasons that you might be here today. We'll cover what would happen to your stuff if you die. I'm going to walk you through what the state's plan would be for you. And that, what I mean by that is if you died without a will or any other plan in place, I'm going to give you an idea of what things might look like upon your death. And then we'll talk about probate and what that is that will probably apply if you die without a plan. We'll also cover some of the different planning tools, such as wills and living trusts, and some of the other documents. I'll talk about incapacity planning if you were ever at a point where you could not make your own decisions about finances or healthcare. I'll cover some of the free tools available to you, my view on when to work with an attorney, and then I will open it up to some questions at the end. And most importantly, I'm also going to give you a really easy route that if you would like to get your questions answered specific to your situation instead of kind of the general plan, how you can get those questions answered specific to you. As a little bit of a disclaimer, while I am an attorney, I'm not your attorney unless we have a written attorney-client engagement agreement. So the information that I'll be providing here is meant to be general, based in Alaska law. And again, I'll give you an option to get more specific questions specific to you. Just quickly, my name is Liz Smith. I live in Juneau. I started 49th Estate Planning about 6 years ago. We actually had a different name. Um, and we changed our name just to really reflect that what we do is estate planning. And my goal is to provide services throughout the state of Alaska. We really take a team approach. So we have a really fantastic team to help people plan for their incapacity and death. I started my legal career working for the state, and I had a lot of different jobs trying to find what it was that I love to do and really not finding it. And part of it is that lawyers, we often fight a lot. We spend a lot of time in court and arguing. And I really didn't want to do that anymore. But I also didn't, when I graduated law school, I wanted to help people. And I didn't actually have a great view of a typical law practice. And I've really chosen to do something different. And also that really fits with estate planning. So one thing that I didn't like about a more traditional practice is hourly billing. I hate hiring people by the hour and just really not knowing what it might cost me for services. But also, it's really hard to have a conversation with people and get to know our clients if we have to keep track of how much time we're spending with you and keeping that clock ticking. And I think it's a disservice to someone trying to get their planning in place and talk about family and protecting family to pass assets on if you know that every time you're having a conversation with your attorney, the clock's ticking. But then the other aspect of that is planning is a lot more than just legal work. So it's important. There's aspects of what we do in our office that are really important for an attorney to do. If you decide to create a trust or you have a will in place, walking you through how to design and how assets will pass on is a really important part of the process that needs to be done by an attorney. But then there's other aspects involved to make sure the plan will work when you die. I have a friend whose father paid well over $6,000 for his estate plan, and his goal in doing so was to keep the family out of court when he died. And then he passed away, and they were all in court for years fighting with his ex-wife, had been his goal to avoid that. And my friend thought, well, surely that attorney committed malpractice. Like, what did they do wrong? And she started looking into it and realized that what the attorney did was really common. The attorney did the legal work and then gave him a set of paid documents and said, now you have to go do X, Y, and Z to follow up. And then those things the follow up didn't happen. So the plan didn't actually work when he died. The other thing I've learned as I got started in the practice is really the importance of providing education to the people that will be involved in the plan. My grandparents, they started getting their plan together when they were adults at a pretty young age, and they created a trust in California where they lived. And that trust changed many times as life shifted. My father passed before both of his parents, and they went in and updated the trust then. They updated their trust as assets would change and some different changes around family members. And as they started meeting with their attorney over time, they also started bringing in my aunt, who would later serve as trustee. And that really helped her to know and have an idea of what was in their plan and also build that relationship with their attorney so that when my grandfather was the last of my grandparents to pass in 2020 at 100 years old. Um, my aunt already just had some trust built up, and it really helped her through the process to have someone to work with and already have some trust with them. And so we've copied some of that, taken that advice, and just seeing how well that worked. And we offer family meetings and also have a plan to help our clients make sure that everything stays up to date throughout your lifetime. Um, so I will talk a bit later more about how we work. And then we have attorneys that you'll meet with initially and then work with the team. But I wanted to introduce you to a couple of attorneys that you might meet with if you end up deciding you wanted to work with us. So this is Hannah. She is living in Wrangell and joining our office, serving clients both virtually, but then also traveling throughout Southeast Alaska. And we'll be able to meet with people in most of our communities in person when she is there. So if you wanted to work with us and you live in a different community than our main office in Juneau, let us know, let Stephanie know, and she may be able to get you scheduled when we are in your community. And then this is Gloria. Gloria lives in Glen Allen and she serves clients virtually. She's also our attorney that helps when our clients pass away. She's going to help the person named as personal representative or successor trustee navigate the distribution of assets at that time. So, what brought you here this afternoon, spending this lunch hour with us? Perhaps your goal is to make sure that your family will be protected if something happens to you, and the assets will be passed the way that you want them to. Maybe you want to make sure that your family doesn't pay estate taxes unnecessarily, and just have peace of mind knowing that things are set up to reduce the cost of distribution of assets. Or maybe your goal is really to make sure that you would be protected in the way that you want to be cared for if you're not able to make decisions about your physical care, about your health care at some point in your life. And my goal will be to cover all of these today over the next half an hour or so. So if you die without a plan, just to start with the real nuts and bolts stuff, the state is going to have a plan for you. And that plan is probably going to be probate. Probate is a court proceeding that is required if you die with assets in your name to pass those assets to whomever is going to inherit. In Alaska, the process of probate typically will take 12 to 18 months, and that's if everything is going smoothly. The process is handled by someone called a personal representative. Many other states refer to that role as an executor. So may be more familiar with the word executor, but it's the same as the personal representative. Um, if you die without a will, there's this law that says who has priority to serve as your personal representative. And that will be if you're married, that would be a spouse. If you're not married and you have adult children, your children would have priority to serve. If you don't meet either of those categories, there will be some close relative that would have priority. If no one steps up to serve, there are provisions for someone else, like a friend, to petition the court to say, hey, no one's available to serve, and we need to distribute assets within this estate. So think about in your own life who that might be. Who do you think would be have priority to serve? Is that the person you want to serve? If you have, let's say, three adult children, can they all agree who would serve? Because they all have equal priority, or would there be an argument between them, or potentially just stress trying to figure out who would do it? It's kind of a lot of work, which I'll talk about in a moment. Um, and then if they can't agree, then a judge is going to have to decide, which is really going to increase the cost of the distribution as well as the stress level. Once the personal representative is appointed by the court, they get a piece of paper, an order from a judge that carries a lot of power. That order allows them to um, essentially gather up the assets that you have and distribute. So they have to follow certain rules about who is going to inherit the assets, but there's a lot of authority within that. If there is a home or other real property in the estate, are they going to sell it, or will that be passed to one of the beneficiaries? If it passes on to the beneficiaries, how does everyone figure out the value, what that home is worth, and agree to some kind of buyout of that property? Sometimes with investment accounts, how are they going to be managed during the administration period? Do they get distributed in kind or cashed out, etc.? And then the personal property, how will that be divided amongst the beneficiaries? Sometimes that's what people argue over the most because the personal property tends to carry the most sentimental value to family members. Now, if you die without a plan, who's going to inherit assets? That the statute will say how that is going to be distributed. And for some people, what they hear in terms of what the law is exactly what they want to happen. So that's great. And for other people, it's very different than what you might want to happen. So if you are married and the two of you have children jointly, then all of the assets in the estate pass to the surviving spouse and then equally amongst those children. But if you are married and you have children from a prior relationship, then upon your death, the law says that some assets would pass to the spouse and some assets would also go to your children. Um, and then if you are married but do not have children, that's my own personal situation. My mother is still alive, and so the law, if I die without a plan, is my husband would inherit a portion of my estate, and my mother would as well, which is not what I want, and I'll come back and talk about that. But hopefully that gives you some idea of what could happen. If you have young children under 18, they cannot inherit. So a judge would decide who will, they're going to get the money for their benefit. They just can't hold it and manage it. So a judge would decide who would do that. And probably that would be the person the judge appoints as guardian. So who would raise your children. They will also have control of the funds. And then once your child turns 18, any remaining funds in the estate that were set aside for them, they would have access and control at 18 and could do whatever they wanted with those assets. The process of probate can be expensive. There's a number of different fees involved in going through the probate process. There's a quote here that's really tongue-in-cheek, but it says that probate's a lawsuit you file against yourself with your own money for the benefit of your creditors. In Alaska, we do have an exception, and if three certain conditions are met, then probate would not, your family would not have to go through probate. There's a different process to distribute assets, and all three of these must be met. So first, if you do not own a house or other real property, if the vehicles you own are worth $100,000 or less combined, and if the entire value of assets is $50,000 or less. So again, all three of these must be met to avoid probate. When we look at the last bullet with your assets $50,000 or less, these are assets that would be in your name without a beneficiary designated. So usually if you have life insurance or retirement accounts, and by retirement, I mean a Roth IRA or an IRA, or 401k, those types of accounts, those typically have a beneficiary designated, and that beneficiary designation controls over everything else, and also means that those assets would pass on to the beneficiaries and not through probate. That means that they're not going to be counted in the 50,000. So what we're usually looking at with the 50,000 for our clients is money in bank accounts, potentially money in a brokerage account, and then also the value of boats that are not considered vehicles. So if you just heard that, or maybe you have family that have gone through probate and you know that you don't want your family to go through probate, um, very important is that a will not avoid probate. Um, a will has some great benefits, but many people I talk to think, well, I have a will, everything will just happen automatically. And that is not the case. It still has to go through probate. A fully funded living trust does avoid probate, and I will come back to that in just a moment. Before I do, I like to just talk about taxes very briefly. This slide is fairly useless, so don't worry too much about it. But when um, assets pass to a beneficiary, will they have to pay tax on it, right? Many people think that they do. Um, in Alaska, we do not have an inheritance tax. So, the state of Alaska, I could inherit $1 million from my mother. Won't happen, but let's just say. And I would not pay any taxes on those funds in the state of Alaska. We are subject to the federal estate tax as Alaska residents. Um, and the federal estate tax is structured so that assets are taxed that pass on, but only over a certain amount. And that certain amount fluctuates over time. But this year it is $15 million. So if I could inherit 14.5 million from my mother and not pay taxes on that distribution. Um, all of the slide is meant to show is that when we look at a state taxes calculation, the life insurance and retirement will be included along with all the other assets. Um, and so the only taxes, I'll just note like an IRA or 401k, those types of accounts that you'll pay income tax when you take money out, your family will as well. So sometimes there are taxes, sometimes there are capital gains taxes if an estate takes a while to administer, but generally no inheritance tax unless it's over the federal exemption. Now, there are neighboring states, Oregon and Washington, for example, both have an estate tax. So if you own property in a different state, it's very important to be aware of their tax rules because that could impact you, and there might be ways to plan around it or at least prepare your family for it. So let's talk about some of the different planning tools available. So I covered a rough idea of what would happen if you die without a plan. What could you do to control? So one of the most foundational planning tools that I'm sure you're familiar with is a will. A will allows you to keep your family out of conflict. With a will, you get to decide who you would want to be the personal representative and handle the administration so your kids don't have to fight. But you also get to choose who's the best person. Is it not one of your children at all? Is it a family member? Who do you have in your family that would be best suited? You also get to decide with a will where your assets pass instead of relying on the state laws. If you wanted to leave some money directly to grandchildren, or you would want to leave to charity or a sibling, there's certain things that are probably not going to happen under just the state laws. Or in my case, if I wanted to leave everything to my husband, I could do that through a will, so my mother wouldn't inherit. If you meet those three criteria, you have assets, you wouldn't face probate anyway. A will is a great tool, could face probate. And then a will is how, if there are young children, how you would name who you'd want to raise them if you couldn't. The next really foundational tool is a living trust, also known as a revocable trust or a revocable living trust. The trust is an entity that has can own certain assets that would otherwise go through probate. So you would transfer your home and your bank accounts to this trust and then continue to manage and control those assets as a trustee. By doing that, by creating a trust and then funding it, you keep your family out of court, out of conflict and out of court. So you get the benefits of a will, but the added benefit that your family does not have to go through court when you die. That means that administration of passing on assets is typically much cheaper than dealing with court. It also can happen much more quickly and also keep things private. So sometimes I meet with people and their main goal is just to keep everything in their family. They don't want to file in court, which anybody can go to the courthouse and get a sense of who's inheriting what. So a trust is how you get to keep everything private. You can sometimes have more control with a trust. That very much depends on your family and your objectives. But sometimes I meet with individuals and or families, and what they want to happen clearly needs to be through a trust rather than a will. That really just depends. And then there's three categories that I want to talk about in the trust column. These are trusts that get created after you've died. Sometimes that means that they can happen through the trust would be created um, through a will. Sometimes, other times you need a trust to do it. And so that is creating a trust for young children if you don't want them to inherit everything at 18. And with a trust, giving within a trust, you can say, I want, my child or my loved one, my niece, my nephew to inherit, half at age 25, the rest at 30, or whatever ages and stages you choose for distribution. The other category of a trust that can really help is if you want to leave assets to someone, but you are concerned about how they would spend those assets and that it could be potentially harmful to them or just a loss or enable them to make decisions that you don't agree with. And that can look like however you want it to look. So, to share a personal story, I said I would come back and talk about my mom. So my mother was an only child, grew up in California, middle class family, and in high school she got very involved in drugs and alcohol, and kind of managed to hold it together, right? I was born, um, and she helped raise me. She was involved. She had a job. She still continued to use, but was involved in society. And then when I was in first grade, her last parent passed away, and her parents left everything to her outright, meaning the inheritance she could do anything she wanted with. And her choice at the time was to sell everything in California, move to Oregon, and she spent 14 years being very unproductive, got into tremendous debt, and just didn't add anything to her life. So there's lots of ideas of, well, obviously, did she have some choice in that? And, what decisions did she make? But it's just a good example of what her parents could have done to be able to talk about that instead of what they chose to do. So they could have instead left everything to her within a trust. And they could have named a trusted friend or a professional trustee to be in charge of those assets and the distribution. And then they could have said how they wanted the assets used. Maybe just kind of generally for her health and maintenance and support to keep her, as needed. Or they could have limited to just provide housing. Or they could have required that she has to have a job, otherwise she would lose distributions entirely. They could have also added a provision that they didn't want her to be used substances anymore if they wanted. They could have defined what that meant and then allowed the trustee to do what was needed to add those restrictions. So really, whatever you want to do, you get to do within a trust, and just guide someone else in how distributions are made. And sometimes just simply having someone else manage will protect the resources. And then the flip side is if you want to leave assets to someone who's actually very responsible with money, but you want to provide some asset protection, you can do that very easily by leaving to them within a trust designed to protect assets from any creditors that your beneficiary could have. If you think of like lawsuits or other litigation that can happen, but it can also protect assets from divorce. So if you wanted to leave to a child and they inherit and then later divorce, if assets have been given to them within a trust, they're not considered part of the marital estate and wouldn't be divided when they get divorced. Some people also really have, accumulated wealth during their lifetime. You worked really hard, and maybe it's important to you to kind of keep everything within the bloodline. You could leave to a child and then say that upon their death, it's going to pass on to their descendants. Personal property, I always just like to mention, thinking about certain things. Again, these are the assets that families sometimes can fight the most over. You don't necessarily need to list out everything or designate who gets what, but thinking through, are there certain items that your family might argue over, and how do you want to distribute them? Now, pets are considered personal property. And so we always ask as well about their pets. Some people choose to leave some money with pets. You can even create a pet trust where money has to be used for a pet. And or just designating who do you want to have pets and really thinking that through. If you died with pets, what does that look like? If you do have young children, we also do in our office, we have something called the Kids Protection Plan, and that's helping clients plan for the short term as well as the long term. So my mentor was early in her career. She had a trust established. She had named guardians, but those guardians lived out of state. So she had everything set up. And there was a night where she went to dinner with her husband, and they left the kids with a babysitter. And what she realized is that if she was in an accident, they were in an accident on the way home, the babysitter would call the police, and probably the kids would end up in state's protective custody for a period of time until things got sorted and the guardians arrived. Um, and she created this kid protection plan that we also use to name temporary or short-term guardians. And there, what we're doing is, if you want to name long-term guardians, but they're not local, we provide paperwork to name people who are local that your kids know, so that if there is an emergency, someone else can step in so that your children are with people they know, ideally, and that you already trust, rather than a stranger who is probably a wonderful human, but just doesn't know you and your family. And then I like to mention incapacity planning. It is so important to think through, who do you want to make financial and healthcare decisions for you, and then documenting who that would be. And documents include power of attorney, healthcare directive. There's kind of a lot of set of documents that all have different names, but the goal is just who can make financial decisions for you, who can make healthcare decisions. When it comes to financial decisions, you uh, can identify exactly which certain powers that you want to give. We recommend being very broad. There are some free forms that the state provides that's better than nothing. If you Googled Alaska Power of Attorney or Alaska Healthcare Directive, it is also something that we do in our office. I do recommend having some guidance with these documents. I love that we have free ones available and have been very pro doing them. I'm a little jaded right now because I had a meeting just recently and someone didn't, this actually happens a lot, where someone did it on their own, it just didn't give the right powers. Now the person's incapacitated and I'm left, the family can't actually do the planning that's needed, and will probably yeah, it's just a really sad situation. So get guidance in the powers. And then I also, sometimes people think, well, I'm married, my spouse can do everything. And so I'll just walk through a kind of what if scenario to help you think about why it is so important. So if my husband and I have a house that we own together, with that, not in a trust, but just in our names, and let's say that I am in an accident, and for whatever reason he needs to have funds to pay for my care, or he needs to move and he needs to sell the house, but I'm still alive. Think about who has to sign the deed to sell the house. Well, we would both have to sign the deed to sell the house, but if I am unable to, need care, I can't make my own decisions, maybe I'm in a coma, then if he does not have power of attorney to sell the house on my behalf, his only option would be to go to court and petition the court to be my guardian. So that would cost a lot of money to hire an attorney to petition for guardianship, and could take months and months to do so. So there's a path. If I had given him power of attorney, great. He would just be able to sell the house and sign for me as my power of attorney. But guardianship is the court's ability to give someone power over another adult. And in order for a judge to sign off on that, there are a lot of things that have to be proved in court. An expert has to speak to my capacity to make decisions. There's just a lot that has to happen that will take a long period of time to do so and probably cost money in terms of attorney's fees, and potentially some court fees as well. Now, if that happened and he was appointed guardian and finally able to sell the house, well, as my guardian, he's going to have to file in court on an annual basis and tell the court exactly what funds he spent for me and how and why. And then every 3 years, the court would send out a court visitor if I remained incapacitated. So it's a big, big burden for your loved ones if you have not designated and given them the powers that they would need for you to take care of you the way that you would want them to. The other thing about getting powers of attorney in place now is that that gives you the power to choose who you would want to make the decisions for you. So your family isn't left deciding, and a judge doesn't have to decide that you've set out what your wishes would be while you're able to make those decisions. I also recommend that you update powers of attorney every 5 to 9 years at least, keeping things up to date. And then as I begin to wrap up, this is sort of more of a public service announcement, and that's thinking about the payment for long-term care. If you needed care in a nursing home or assisted living facility, how are you set up to pay for it? Our insurance, Medicare and typical health insurance, will not cover long-term care. If you have long-term care insurance, that could help. But outside of that, you could be stuck paying the bill. Our nursing home in Juneau is $30,000 a month, give or take, Wildflower Court. And throughout Southeast Alaska, throughout Alaska, it's usually 25,000 to 45,000 in that range per month. So if someone's receiving that kind of care and paying those funds, you could have saved a lot in your lifetime and still not be able to pay for care for very long. There is planning you can do ahead of time. There is planning that we do in our office that can set you up to protect assets should you need care down the road. And that can be coupled with long-term care insurance and other resources. And then there's also emergency planning. So if you know someone in that situation facing a $30,000 a month bill, we can probably help them save some assets, which can just be a really big relief for family members. Because what happens if you're paying out of pocket, once you have exhausted funds and you only have about $2,000 left, then Medicaid covers the care. But then what? What if you have a condo and you need condo fees paid, and you end up in a nursing home and and you're on Medicaid, but then you end up back home, you're going to have no money left to pay for condo fees, for an example. I'm dealing with something like that right now. So just know that there are things that can be done. I think a lot of people just aren't aware of what's possible, and that's something that we do in our office. Now, we've been talking about locking about assets and passing on money to your beneficiaries, but really, if you had to choose between the people you love receiving your money or your values, insights, stories, and experiences, those other intangibles that you want to pass on to your loved ones, what would you choose? And that is just, of course, to highlight that it's not a binary decision. You can do everything. And then my views on working with an attorney. So that would mean our office or another attorney's office to get your estate plan in place. Obviously, I'm biased, and that is not just because it's our business, but also because I see how complicated things can do. Again, I'm just heartbroken this week just seeing a power of attorney that just wasn't executed properly, and it feels hopeless for the individual. So yeah. If you want the added assurance, the people you love stay out of court and out of conflict, if that's important to you, I think it's helpful to work with someone. The thing with planning, my husband just recently was gifted some sourdough starter. I know we're 5 years behind behind the trend. And he made his first loaf just this week. And it was great, but he's also learning a lot. And now he gets to try again and make an even better loaf. And I'm excited to see him, make changes and get better at it. And it's really exciting. So you get to try again. With planning for your incapacity or death, it's you kind of get one shot. I mean, maybe you'll be incapacitated and then get better, but otherwise it's one shot. It won't take effect until like in terms of your main estate plan until you die. So sometimes it's just nice to know I have someone looking over, it's more likely to work. If you want the people you love to have someone to turn to when something happens to you, a lot of clients will call us up and that's their main goal, is having a connection for when they pass. If it's easier to hire someone to do it, if you've been putting it off, if you do have an interest in creating a trust, I do recommend working with an attorney. I have yet to see sort of an online trust that will work the way that someone wants it to. Um, if you are in a relationship and unmarried, then there's some planning that we can do that's probably not going to be incorporated into the statutes. Blended families, thinking of there's really great planning we can do to protect all the children. So when one spouse dies, assets could all go to the surviving spouse, but in such a way that all the children will inherit, which can provide a lot of peace of mind. Anything else unique? Yeah. And then I'll answer. I just saw a question come in, which I'll answer at the end. So then I'd ask you to think about, is there something you learned here today that's important to you and what that might be? So something, Brian, something, had you spend your time here, is there some kind of something you've heard of, like maybe you want to provide asset protection for your children, maybe you want to avoid probate because of the time it takes or the cost involved. And then we want to help you take your next step, whatever that is. And I'd really encourage you to commit today to what that next step is. If you think that you are ready to move forward and you want to get a plan in place, and or you have questions running through your mind of, well, my situation is different, what about X, what about Y? Then I want to help you get answers to those questions. And what I would offer to do that is what we call our life and legacy planning session. So what I'm doing is inviting you to schedule a meeting with an attorney in our office for this life and legacy planning session as your next step to get answers to questions and also start the planning process. We schedule that for a 2-hour meeting, a 2-hour working meeting. We ask you to fill out homework ahead of time. So I'm sure you're all thinking about what the cost is for that meeting. If you, for coming here today and attending the webinar, and if you fill out the homework ahead of time, which is an inventory, which asks you to tell us about a little about your family members and the assets you have and how they're titled, then that meeting would be free. So you came here today. If you do the homework, you get a free meeting with an attorney. During that meeting, we start by asking you to tell us about your family and the family dynamics. We look over the assets that you have and how they're titled and tell you what would happen now. So in your for your particular family, what do things look like now? And then you tell us what about that works for you and what doesn't. And then the reason we schedule for 2 hours is that after that initial point, if you decide that you want to work with us and you are ready, we would just design your plan right there. And whatever that plan is that's right for you from an outcome perspective and also a cost perspective for you. So if your next step is that life and legacy planning session. As our job is, I am not blind to the fact that estate planning is what so many people put off, right? Sometimes we meet with people that are so happy to get the plan in place and it gives them such peace of mind, but oftentimes it's hard conversations and maybe something you don't really want to do. So we also will offer you, if you decide that is your next step and you book an appointment today for the life and legacy planning session, we will give you $250 off if you end up working with us and moving forward. To schedule that meeting. In just a moment, I'm going to talk about what it's like to work with us. And to schedule the meeting, we will be sending you an email with a link, and you can just find a time that works for you. You have to schedule today for the $250 off. If you reschedule once, we'll keep that $250 off, but just for one reschedule if you need to talk to someone about schedules. I like to cover what it's like to work with us, just so you know what our process is, as you decide if that meeting is the next step for you. So you would book your appointment, again, doing that today. If you are not ready to move forward today, we also would be happy to do a 15-minute meeting with you. That will be with Stephanie, who's on the line today, or another team member to go through, answer any questions, whether that's the right step for you to book that meeting. So either book a 15-minute, or if you're ready to go forward, once you book the Life and Legacy Planning session, we send you a pre-meeting packet in the mail. And then once your appointment's booked, you'll receive a link to fill out the inventory I mentioned online. That usually takes anywhere from 30 minutes to 2 hours, depending on what you have and how organized you are. And then we have that Life and Legacy Planning session. When you're booking, I recommend booking at least a week out to give you time to fill out the inventory. After that meeting, if you've designed your plan, we'll schedule signing. And that's going to be 4 to 6 weeks out, typically, sometimes a little bit longer. After signing, and we can meet with you anywhere throughout Alaska. Like I said, we also do a lot of traveling. So if you wanted to meet in person when you book, or before you book, let us know. So book that 15-minute call, and we can see if we can arrange that. We also offer a legacy interview. So I talked about sharing your stories and values and insights. So one way that we help with that is by providing an option to do a recorded interview, to share some of those stories, to pass on in a video format. That is optional, but encouraged. And then after signing, you may have things to do to follow up to make sure that plan works. And then we hold a third meeting we call the binder delivery meeting, really to wrap everything up. And we have different follow-up options after that. All of our clients, we meet with you for free every 3 years to make sure things stay up to date, which is so, so important. It's amazing how much can change. And then we also have a client care program for clients that want more ongoing support. Meet with us anytime, and have, cheaper access to updates. And we have some great perks within that client care program. The cost, like I said at the beginning, all of the work we do is on a flat fee basis, but you can expect to pay from about $3,100 to upwards of $12,000 plus, depending on what it is you're doing. So during that initial meeting, we would look over the different plan options, so you get to decide what makes the most sense for you and your family. If you already have a will or a trust, we still invite you to schedule that Life and Legacy Planning session. We may charge to review. So when you fill out the form, we'll be sending you to schedule an appointment. Please just let us know, and someone will reach out and let you know. We will give you the $250 off the review if you schedule today. And so a full trust review, if you, a few years ago had a trust created by an attorney, we typically charge $950 because we need to look through it all and guide you into what would happen under that trust. So we would take $250 off of that, but it may be less. If you have a trust that's older, we may not charge you that much. So just let us know and we'll walk you through what it would be. You may have an insurance plan through your business. APEA, ASCA, and IBEW are the most common. All right. So this QR code will work. You also will be getting an email with the link as well, but I'm going to leave this page up for a bit here. If you want to take a picture of the QR code with your phone, that would allow you, you'll get to a form that just would ask for your name and number, and you would be able to add that in, and then book. You'll get an email or a text, and then for a longer form to actually book your appointment. And I am going to invite Stephanie to say hello again. She would be meeting with you, helping you prepare for that session. So I'll ask her to say hello and then ask if you have any questions for either of us about planning or whether that session is right for you. So, all right, Stephanie.
Thank you, Liz. Yes, hello. My name is Stephanie. I'm sure you all got reminder emails and follow-ups from me ahead of this meeting. You should all also by now have, or within the next few minutes, an email from me inviting you to go ahead and book that 2-hour life and legacy planning session that Liz spoke about. There's a link in there that should be a quick and easy way. If you don't have a chance to scan the QR code, you can use that. It should be in your inbox now. After you do schedule that meeting, I will be following up with you just to make sure that you have all the information and that you know what to expect, to be prepared, and also checking in just to make sure that you're able to get that inventory in time. So I will be working with you from sign up until your appointment. Feel free to respond to my email if you do have any questions or if you'd prefer to schedule a quick discovery call with me before booking that 2-hour meeting.
Great. Thank you. And I'm going to